All rise. The North Carolina Court of Appeals is back in session.
Thank you,
Be
Ms.
seated.
Orr. We're back for the second case. In case someone was not here earlier, the panel to my right is Judge Fred Gore. To my left is Judge Darren Jackson. I am John Tyson. We have the case of Phillips versus McRae. Are there any preliminary matters?
No, Your Honor.
Okay. Then we will hear from the appellant.
Thank you. Judge Gore, Judge Tyson, and Judge Jackson, may it please the court, my name is Liz Arias, and I am here today on behalf of the appellants. And I would like to reserve 5 minutes of my allotted time for rebuttal.
Okay, thank you.
The appellants ask today that this court reverse the order granting summary judgment to the appellees and remand the matter back to the Superior Court for trial. And the standard of review of an appeal from summary judgment is de novo. At the center of this dispute is the testamentary intent of the late Hugh Mcrae. Mr. Mcrae died in October of 2018. He was survived by his wife and 4 children. 3 of his 4 children were from his first marriage. His 4th child, Meg, was his only child with his surviving spouse. And at the central of this dispute is his estate planning documents, which provided that at his death, his estate would be divided into 2 trusts, a marital trust and a family trust. The marital trust is for the lifetime benefit of Mrs. Mcrae. The family trust is for the benefit of all 4 children. And at Mrs. Mcrae's death, any assets that are left in the marital trust will go into the family trust. Appellants are the co-trustees of the marital trust and the family trust. And the appellees are Mrs. Mcrae, the surviving spouse, and her daughter, Mr. Mcrae's child with her, Meg. This dispute is over whether the marital trust for Mrs. Mcrae qualifies as a 100% fully countable trust within the meaning of the Elective Share Act. Mrs. Mcrae filed an elective share claim that was stayed pending the resolution of this matter through the trial court and now on appeal.
Is there any dispute over the value of the estate?
There is no dispute over the value of the estate, at least not that I've heard. The estate tax return has been filed. That value has been reported.
So it's just whether or not the trust, the marital trust, was sufficient, equal to, or greater than the amount that she could have claimed as an elective share. Is that the issue?
That is exactly correct. The calculation hasn't been done down below, but the understanding of the attorneys and I think the parties is that if this trust counts at 100%, it is unlikely that she will receive anything extra as part of her elective share.
Okay.
Counsel, is it also true, correct me if I'm mistaken in reading the language, is the family trust the residuary beneficiary of the marital trust?
It is. So any assets that are left in the marital trust when Mrs. Mcrae dies goes over to that trust, which is for the 4 children.
Okay, thank you.
So there's no other beneficiaries.
So the daughter between Ms. Mcrae and Mr. Mcrae, she's a beneficiary, and she would be a beneficiary under either one or both?
All 4 children, including her, are the beneficiaries of the family trust.
In equal shares?
Yes.
Okay.
The trust is for the benefit of all 4 of them.
Now, you referred to Meg. I would take that to be Marguerite.
That is correct.
Okay.
Yes, Your Honor. And Your Honor, Judge Tyson, you hit on the issue exactly. This matter relates to whether or not the value of that trust is counted either at 100% or only at the actuarial value of Mrs. Mcrae's life expectancy. And under the Elective Share Act, there are special provisions that allow a trust to be counted at 100%. And that's because when the General Assembly passed the Elective Share Act and set a spouse's elective share rights, they did not require that it had to be satisfied outright. So a testator who wants to do an estate plan can leave the requisite share in a trust and satisfy the elective share statute.
Now, tell us where Judge Gorham got it wrong.
So Judge Gorham got it wrong because Judge Gorham ruled as a matter of law that the marital trust does not comply with the statute.
And the order, which I've read, does not go into detail. It just makes a kind of a blanket statement, and the order does not tend to show why she felt that way. Is that correct?
It does in part. And if you look at, she said, first of all, in her first paragraph, this is page 530 of the record, With respect to plaintiff's motion for summary judgment, the court concludes as a matter of law that the marital trust does not qualify as a fully countable trust, which means she had to determine that if you read the marital trust terms and you read the elective share statute, there's no way they can comply as a matter of law. Then she also said in the third paragraph of her order on page 530 that with respect to the motion for summary judgment as to count 3, which is the section 415 claim, that the terms of the marital trust are unambiguous and modification is not authorized.
Is that not an actuarial computation? Isn't that a question of fact? Is that what you're arguing?
No, Your Honor. What I'm arguing is that this trust does not require an actuarial computation because it should count at 100%. And the applicable
On its face?
On its face. And I'm saying that if you determine that on its face you don't think it is absolutely crystal clear that it complies with the statute, then there is an ambiguity. And we ought to be able to enter extrinsic evidence of Mr. McRae's intent, which was clear from all of the evidence in this matter, that he intended in his estate plan to accomplish 2 things: to benefit his wife for life, but to make sure that at his death, all of his assets went in equal shares to his 4 children. And the record is crystal clear, multiple instances of him working with his estate planning attorney and his closest confidant, his accountant, Bob Warwick, to confirm that this trust, as drafted, complied with the elective share statute. He even had his attorney mail him a copy of the elective share statute. The record indicates that at one point he sent a letter in 2009. His attorney sent a letter to him saying, "Mr. Mcrae, you've inquired about the law in North Carolina covering the right of a surviving spouse to dissent from the will." He later sends his own calculations comparing what he was leaving to her in trust versus what the elective share amount would be. There's even a handwritten note from him to his accountant that says, quote, "Talmadge is checking result to be certain the will exceeds North Carolina law for spouse's share and would not be likely to be contested." And then a year before his death, he sends questions to Talmadge, his lawyer, who responds and answers a question about whether there is a legal rule or requirement that a testator leave to a widow sufficient financial ability. He believed, and the evidence showed, that he thought this trust qualified. And the issue here is whether or not it does. Appellees argued to Judge Gorham, and Judge Gorham ultimately agreed with them, that unequivocally, on its face, unambiguously, it does not comply. We argue that it does.
Okay, I go back to my earlier question, and this may be where I'm not tracking. Isn't that a value calculation? Isn't it purely a value calculation? She would be entitled to a certain percentage of his estate as a spouse, correct?
50%.
With multiple children? With
Yes.
4 children?
Because she's married more than 15 years.
Okay, so she would get half. So if she's entitled to half under the statute as elective share, isn't the calculus, does the trust give her at least that much or more?
Yes, Your Honor. Well, no. I mean, yes, we agree with you. That's what we argue. He left 50% of his estate into the marital trust. She's arguing you shouldn't count it. Like, let's say $8 million went in the trust. She's saying, I didn't get $8 million. I only got the actuarial value of my life interest in the trust, which is, say, $1.5 million. So I am $6.5 million short, so the estate needs to give me an elective share claim.
So I guess the true issue then is over the fact that there's a residuary clause of whatever she doesn't spend would go to the children, as opposed, if she took the elective share, she would have 100% control of those assets. Is that correct?
Not exactly, Your Honor. Because the General Assembly said a spouse is not entitled to an outright distribution. In other words, as a public policy decision, the General Assembly said you can satisfy her 50% share by putting it in a trust if the terms of the trust meet the following requirements, and there's 4 of them.
Right.
So no one is disputing that if a trust meets these requirements, you count the whole value of the trust. They are alleging
So
that
do we look at the time it was established or at the time of the death?
you look at the value as determined for estate tax purposes. So generally that's date of death.
So if he had given her, everybody agrees he gave her 50% at the time, and then when he died, it was 35%.
No, that's not the issue, Your Honor. The issue is whether or not the trust was drafted in such a way that it meets the requirements of the elective share statute. No one's arguing there's a decrease in value of the trust or anything. They're simply saying, so the statute, which is 30-3.3A, says that you count a trust at 100% of its value for purposes of doing that
Let me
computation.
ask you this, would she be free to spend the entire balance of the marital trust during her lifetime? Could she exhaust it?
Only if the trustees allow her to do so. And this is why the public policy decision behind the elective share statute makes sense. The General Assembly said you can put it in a marital trust, but you got to do four things. During the lifetime of the surviving spouse, the trust has to be controlled by non-adverse trustees.
Right.
You have to either give her all the income, or you have to give discretionary income. And then you can have provisions in your trust that say, in exercising discretion, the trustee may be authorized or required to take into consideration all of her other income assets and other means of support. And then thirdly, the terms of the trust must meet the following requirement, that the trustee shall distribute to or for the benefit of the surviving spouse out of the principal of the trust such amounts and at such times as the trustee in its discretion determines necessary for the health, maintenance, and support of the surviving spouse.
Did she ever make a request of the trustees that they did not honor?
Not that I'm aware of, Your Honor, but that's not in the record.
Well, that's what I'm trying to say. I'm trying to understand what prompted this dispute.
What prompted this dispute is that she wants the trust counted at less than full value so she can get another several $1 million outright.
I understand that, but so in order to do that, would she not have to show that the value of what she received under the trust is less than the amount she would receive as elective share? Wouldn't she have to show that?
Yes, but that's only one. So if this trust counts at 50%, the clerk will enter that amount in on the calculation now at the clerk level and determine if she's short. The question is, what number does the clerk enter in on that line down below?
And that was my question earlier. If the estate's been settled and the value of the estate's known, that is a known number. Is it not?
The total gross estate, as reported on the 706, is a known number.
Right.
But there's a whole bunch of other calculations that go into the elective share that the clerk has to do.
I understand that too. But, so, we're dealing with known facts. We're not dealing with something that has not fully vested because Mr. McRae's died. The trusts are vested, correct?
The trusts have been created and funded.
Yes, they've been created and funded. So, what I'm trying to understand is what is triggering the dispute here where we don't have undisputed values.
The dispute is that Mrs. McRae has taken the position this trust doesn't comply with the statute and that therefore she should get a larger number. And so we filed a declaratory judgment action asking the trial court to agree with us that it does comply. Okay. Or in the alternative, if it doesn't, to modify it under the trust code to make it comply.
Are you arguing that's a question of fact and not a question of law?
I am arguing that on their behalf, they made the argument as a matter of law, which is incorrect. We believe it needs to go back to trial so that the evidence can be heard to the extent that there's any ambiguity in these documents, it can be determined at trial.
So in your mind, then, the question of fact is not are the relative values.
Right.
The question is, did the trust comply?
Right.
And my question is, how do you know the trust complies if you don't know the values?
Because you have to first know if it complies so that you know which value to use.
I understand. Well, legally, no one's disputing that the trust was legally drawn and that it's been vested and funded, correct?
Correct.
No one's disputing the validity of the trust.
Correct.
What is in dispute is she is receiving less under the trust than she otherwise would have received as an elective share.
No, that's not being disputed. What's being disputed is, let's say it was a $16 million estate, and $8 million went into the marital trust, and $8 million went into the family trust. She's saying that's not good enough. I didn't get my 50%. She's saying, you count that $8 million trust as only like $1 million, because I'm 87 years old and my life expectancy equals 10% of that trust. So just because it's an $8 million marital trust and an $8 million family trust, you only count that marital trust as if it were $1 million passing to me. So I should get $7 million outright.
So she's saying that her life expectancy does not allow her to enjoy the full benefit of the trust. Is that what she's trying to say?
She's saying that under the law, the elective share valuation rule that should apply should be her life expectancy, whereas we're saying it ought to be the other part of the statute that says this trust is the special kind of trust that counts as 100% of value.
Now, in the briefs, it seems like there's been cases that's gone both ways on that, correct?
There's never been a reported decision on this issue.
From any state? From any?
Not on whether this kind of language satisfies the 100% fully accountable trust under our elective share statute.
Did this provision come from some uniform act, or was it unique to North Carolina?
I think much of this was unique to North Carolina.
And you cannot find any precedent whatsoever?
No, Your Honor. And we would say, and that is one of the reasons why we argue that there is an ambiguity. We have a drafting attorney who took the statute, read it, sent it to his client, and thought he drafted a trust that was in compliance with the statute. And now they're arguing that it is not in compliance with the statute for 3 reasons. There's a possibility, they argue, that a non-adverse trustee could be appointed at some point in the future, even though we have always had non-adverse trustees. Then they argue that...
That's a statutory requirement, though, is it not?
What it says is, it doesn't... Now, see, here's the difference. This statute does not say the trust must contain the following language. There's no go-bys, there's no form, there's no requirement that you incorporate it by reference, which we know the General Assembly can do. There's short-form powers of attorney, there's short-form healthcare powers of attorney, there's self-proving will affidavits. This just says, if the terms of the trust meet the following requirements, that during the lifetime of the surviving spouse, the trust is controlled by non-adverse trustees.
That means someone who's not a family member or potentially with some claim.
Or a
Does it
remainder
mean more than
beneficiary.
that?
Correct.
Does it mean any more than that?
It means someone that does not have probably a claim against the trust or is a remainder beneficiary, so the children couldn't serve. So even though he appointed his sons as co-executors and co-trustees of the family trust, he appointed the accountant that worked at his company and then his longtime confidant as the trustees of the marital trust. But they argue it could have non-adverse trustees in the future. Well, it doesn't right now. The second point they argue is that the requirement for principal says that the trustee shall, in the trustee's discretion, be required to make distributions for health support and maintenance. Our trust says may. I did cite in my briefs a case law where a North Carolina Court of Appeals has held that shall in its discretion is interpreted as permissive, not mandatory. So we would argue if this, the statute didn't say put shall in discretion. The statute said it needs to meet these requirements. We have a drafting attorney that said may make distributions of principal. And then the third thing they argue is this, the trust says may make distributions of principal for things that are necessary and prudent. And then there's an admonishment, there's precatory language that says only make distributions for necessities, nothing luxury. The testimony from the decedent himself, the testimony from the drafting attorney, and the testimony from both of the non-adverse trustees is that they interpret that document as complying with the elective share statute, that they believe that they are required to make distributions to her if she needs them for health support and maintenance. She has other independent assets. They're allowed to look at those, but they all testified that they believe this trust complies with the elective share statute. And the court said, Judge Gorham said, no, it doesn't. Well, that means Judge Gorham had to make the decision as a matter of law that the phrase in the statute, shall, in the trustee's discretion, cannot mean may, even though we have the Edens case in North Carolina that's precedential that says no, shall in its discretion is permissive, may is permissive. I would argue that ambiguity is one that we should be allowed to introduce evidence to construe. It means Judge Gorham had to have concluded that a direction to make distributions to a surviving spouse for reasons that are necessary and prudent could never mean health support and maintenance. Here we have a drafting attorney that said he thinks it's even broader than health support and maintenance, that the decedent wanted his wife to be well taken care of.
Basically maintain her current standard of living?
Correct. And we have
above a minimal maintenance type care, right?
Right, exactly. And we have evidence of all these things, of what was intended, of what the trustees think. We ought to be allowed to admit it. But instead, Judge Gorham said, no, even if you have that evidence, as a matter of law, this trust doesn't comply. We disagree because we think there's no reported case in North Carolina on the statute. This statute does not say the terms of the trust must contain the following language, and it doesn't provide a form. It doesn't provide any other guidance to a drafting attorney other than meet these 4 requirements, which our drafting attorney said he did. And then he said in his affidavit, if the court were to determine it doesn't meet the requirements of the statute, that's a mistake. I made a mistake. And under Section 415 of the Trust Code, you are entitled to admit extrinsic evidence of a testator's intent to clear up an ambiguity.
So let's go back to the standard of review on summary judgment. If it is a question of law, then we get to review that de novo of whether or not it's compliant, correct?
That is correct.
And you're saying in the alternative, you're asserting, if I understand in your brief, it's compliant as a matter of law, right? But then you're saying if it's not compliant, then, and it's ambiguous, then we're entitled to put on evidence of the intent.
That's correct.
Okay, so that's your 2 arguments
That is correct.
in a capsule.
And then my third argument is that Judge Willie, at the motion to dismiss, where he denied it, has already ruled on this as a matter of law, that the trust was ambiguous, because they tried to dismiss all 3 counts of the complaint under 12b-6 for failure to state a claim. And the 2 reasons they alleged were that the trust was clear on its face. It was unambiguous. It was not in compliance. And therefore, and I believe the quote was something to the effect, it won't even matter if they put on discovery. It's clear. This trust is unambiguous. And then they come back to Judge Gorham and make exactly the same argument. We put in all the evidence because there was competing motions for summary judgment that were being heard. So we had pages and pages of evidence of intent, and the judge said, no, even if that were true, this is unambiguous. This is unambiguous. Well, Judge Willie already denied the motion to dismiss on the same basis. And then there's one statute I haven't mentioned yet, which is Section 412 of the Trust Code, which says that if there's unanticipated circumstances, a trust can be modified to conform with the settlor's probable intent. And we alleged also that this set of facts, the fact that Mr. McRae asked about the statute, worked with his attorney as confidant, thought the statute was compliant, and then had these issues raised, constituted an unanticipated circumstance. They argued at the motion to dismiss, a mistake can never be an unanticipated circumstance. Judge Willie disagreed. He denied the motion, the 12b-6 on 412. They argued exactly the same thing to Judge Gorham again, and she denied. So we think already the issue of ambiguity and unanticipated circumstance is law of the case.
If Mrs. McRae had made a demand for distribution and it had been denied, what posture would that be in if that was the issue before us today in construing the trust?
If she were denied a distribution under North Carolina law, she has to bring an action for breach of fiduciary duty for failing to make a distribution, and the standard is whether the trustee acted beyond the bounds of reasonable judgment.
So that would be a discretionary review?
Correct, Your Honor.
Okay, so the fact that she's not required to make a demand first to have all the assets given to her at one time.
Well, she can make a request for discretionary distribution of principal. I mean, she's clearly entitled to do that. She has done
Including all of it.
Including all of it. And then it's up to the trustees whether to say, the trustees are not prohibited from saying no. Right. They have that discretion. And the drafting attorney even testified to that theoretically all of it could be distributed to her.
Okay, and let's say that was still less than half the estate. Would she still have a cause of action for the balance?
Yeah. That's the problem. See, the marital trust is in existence. So if she gets an elective share award by the clerk, she still gets her marital trust, just reduced by the amount necessary to pay the elective share.
Right. So my question, I guess my analogy is, if she made a demand and they gave her whatever was there, and it was less than what she otherwise would have been entitled to, she could make a claim for the deficiency.
No, not in the elective share case. That's based on funding numbers at date of death. She can't raise the elective share as a reason why once this is resolved, if she doesn't get a distribution, she has to bring a separate breach of fiduciary duty action.
So again, maybe this is irrelevant, but when do you make the valuation determination, if she got it or not?
Well, you make it as of the date of death, but we've got to resolve the clerk of court. We had a hearing in front of the clerk of court.
Right.
And the clerk of court took a look at this trust and took a look at the statute and said, I can't, there's shall and discretion, there's may. I need the court to interpret the trust.
Right.
We filed an action to interpret the trust, and that's where we are today. So once this matter goes back, once it's finally resolved, the clerk will have an answer to that question, and then the clerk will run the numbers based on date of death values.
Okay, so if we affirm Judge Gore, which I know that's not what you're here for, but if we would affirm her, what would happen at that point?
Then even if this trust has $8 million in it, the number given to the clerk to plug in will be her actuarial value for life expectancy, so 1 million, 1.5 million. And that will be all that's attributed as passing to her under this trust.
So you're saying the result wouldn't change for her either way?
Oh, the result would change for her dramatically. She'd get $5-6 million outright.
In addition to whatever's in the marital trust, right?
That's correct, Your Honor. And the other key point we've made in our briefs is that Mr. McRae's he had two intentions. One was to take care of Mrs. McRae. The other was to make sure that whatever was left at her death went equally to all 4 children. And he was concerned that if anything he gave her outright would only go to her daughter, to the exclusion of his other 3 children. And this concerned him greatly and was the source of all of his constant work for years and years and years on this estate plan.
You're into your rebuttal time, so I'm going to...
I just have one quick, and if you want to give time back, if you could, Judge Tyson, I'm fine with it. In the initial pleadings, I know they were declaratory, but was reformation part of the pleadings in the initial claim in case there was ambiguity identified?
Yes, Your Honor. Yes, we filed, it was 3 claims for relief. We filed a declaratory judgment action that asked the court to construe the trust as being in compliance, but if not, to interpret it as being in compliance. And if the court determined that it could not do that under the declaratory judgment claim, then we asked the court to reform it under Section 415 of the Trust Code or under Section 412. And Judge Gorham denied us on all of those.
What were the requests, or I guess, so there wasn't a need to go down that rabbit hole after the initial ruling from the first judge because there wasn't any ambiguities identified. Is that fair to say?
Well, the first judge, Judge Willey, at the motion to dismiss, declined to get rid of the case because he concluded there was ambiguous language. So he allowed the case to continue. Okay. We then did depositions, discovery. Okay. Then they moved for summary judgment on exactly the same basis that had been argued in front of Judge.
That clears that up.
Thank you.
Thank you.
Hear from the appellee. Good afternoon and welcome to the court.
Thank you, Your Honor. May it please the court. My name is Kim Kirk, and I'm with the law firm Johnston, Allison, and Horde out of Mecklenburg County, and I represent the defendant appellee Eunice Taylor McRae. Also present today is Susan Keelan, and she represents defendant appellee Marguerite McRae. I will be handling the argument today for both of the appellees. Your Honor, at its core, this case presents an age-old story of a dispute between a widow and her stepchildren. But what's unique about this case is that the spouse had been married for 51 years at the time of her husband's death. And that spouse is my client, Mrs. McRae. In this lawsuit, we have stepchildren who have asked this court to essentially perform a redo of their deceased father's estate. But as this court has consistently held in the past, words do matter. And Judge Tyson, as you wrote in the In Re Estate of Sharp case cited in our brief, when the terms of an instrument are clear on their face, it's not the role of courts to step in and to rewrite their terms. Now, this case can be resolved solely by looking at the statute and the words on the page of this trust instrument, and the court's asked to affirm the lower court's order doing so. Your Honors, I had anticipated that I would begin by addressing the procedural issue, the Rule 56, Rule 12. I'm happy to start there, but based on your questions, I'm wondering if the court would prefer that I jump into the merits.
Well, I think the court's very familiar with the standards of review on 12b-6 and with summary judgment. Basically, is there a genuine issue of material fact, and is a moving party entitled to judgment as a matter of law, viewing the evidence in light most favorable to non-moving party? Is that an agreement?
Yes, Your Honor, different legal standards framing two different legal issues. The only other thing that I would kind of draw to the court's attention is that the non-adverse trustee requirement, among other arguments, was never presented at the Rule 12 stage, and the Rule 12 order here is silent, does not contain any conclusions of law. So I'm happy to answer any other questions.
Why is the agreement not ambiguous that would require us to send it back to have evidence of the intent?
So, Your Honor, what's interesting here is that I haven't actually heard the appellants identify any particular ambiguity.
May versus shall?
Well, are they identifying that in the statute, or are they identifying that in the document? And here's why I say that. We all agree that this trust instrument only provides for permissive principal distributions. There is not a dispute on that point. We all agree to that. The question that they have raised is whether the statute allows for that or whether the statute requires principal distributions when the trustees determine that Mrs. McRae has a need for her health, maintenance, and support.
Now, your client has not made any demand for any distributions of principal, is that correct?
Your Honor, I do not agree with that characterization. There have been requests made. I won't belabor the point because it's not in the record, just given the timing and the nature of the issues here rather than before the clerk. But demands have been made, budgets have been provided, and amounts have not been paid. So I don't agree.
Let me ask you this. Can the legislature, as a matter of policy, allow a person, male or female, who has children by multiple marriages, can they not set up a provision where a surviving spouse would receive at least half the elective share as determined by a certain date, and then provide the remainder 50% would go equally to the children, and whatever was left that was not exhausted from the marital trust, that in and of itself would also go to the children for equal division? Is there anything wrong with that?
There is nothing wrong with that. It is done all the time and consistently throughout estate plans.
And is that person, when they died, are they entitled to the confidence that those wishes will be enforced by the court?
They are entitled to the confidence that those wishes will be, that they will be enforced by the court when they comply with the statutory exception to do that.
Okay, now where is the deficiency here?
Thank you, Your Honor. So the statute 30-3.3 AE1, it provides at the beginning, in the lead-in paragraph, the default rule, which is when you have a trust, here's how you value it. You take, as property passing to the surviving spouse, you look at the surviving spouse's life expectancy and interest calculation, and then you determine the value of that trust. However, if you want the trust to do what Your Honor has asked about, there's a special exception in the statute, and that's the provision that we're talking about here today. In fact, Your Honor, I'll read to you the lead-in on the statute. So it's the default rule, and then it says, however, in valuing partial and contingent interest passing to the surviving spouse, the following special rules apply. And so there is a way to do this. It's a special way, and it's a very narrow exception to the typical valuation rules for a trust, but it absolutely can be done, and it is done successfully every day by estate planners. And here's how you do it. The statute tells you how. It says the terms of the trust must meet the following requirements, and then it lists 4 criteria in the statute. These are not magic words. The statute does not need to be mirrored, but there needs to be some assurance for the surviving spouse in the trust instrument that the trust is going to meet those requirements. And here's why that is so important. The statute of limitations for an elective share claim is 6 months. And so when somebody dies, the surviving spouse has 6 months to determine if they can rely on the trust that's been left for them, or if they're not confident it provides assurances that they will receive those principal distributions for their health, maintenance, and support. And so within that 6 months, they need to make that call. And that's why the statute, the lead-in language on the statute, it says the terms of the trust must meet the following requirements. Because the surviving spouse doesn't have the luxury of waiting around until year 3 when an adverse trustee is appointed, or waiting until year 4 when the trustees decide, well, what I did the first 6 months when I was making principal distributions, I'm not required to do it, and so I'm not going to do that anymore. And so that is why the terms of the trust are so important. And the terms of this trust do not fulfill 2 of the 4 statutory requirements. And I'll address each of those, but I did want to clarify.
Let me ask you one thing before you
Yes.
go there. Give me a scenario where a adverse trustee could be appointed and still be compliant with the statute,
Absolutely. Well, and still be compliant with the statute?
or compliant with the trust itself.
So this, and you've hit the nail on the head. This is the issue. So under the statute, the surviving spouse is entitled to a trust that by its terms will have a non-adverse trustee for the surviving spouse's lifetime. This particular trust does not provide any assurance whatsoever. It is completely silent as to who can be appointed as a successor trustee, and there's no dispute about
But
that.
wouldn't the statute control that in the effect that you would have a successor trustee? Wouldn't the statute require that person be non-adverse?
It doesn't.
The statute does.
The statute requires that you have a non-adverse trustee on the terms of the instrument in order to qualify as a fully accountable trust, but that's not something that can happen after the fact. You have to look at the terms of the instrument.
So you don't think the statutory duty would necessarily follow to any successor trustees to be
Well,
non-adverse?
So, Your Honor, it's actually not, it's not a statutory duty, but it's a statutory exception. And to fit within that exception, you've got to have non-adverse trustees for the surviving spouse's lifetime.
Because the next question I have is, how can an adverse trustee meet its fiduciary duty under the trust?
Well, and that's another good question, because in this particular case, it is conceivable, and perhaps even possible, that one of the trustees who's in his mid-80s could appoint a successor trustee. There are no limitations on his ability to do so, and it could be one of Mr. McRae's 4 children, who is also a trustee of the family trust. He has a personal incentive to ensure the trust is not invaded. The principle of the trust is not invaded, so it will roll over.
Well, wouldn't that be subject to challenge because that is an adverse trustee?
And that's the other interesting thing about this trust. Probably not a very successful challenge because the trust itself contains language admonishing principal distributions. And so when a trustee picks up this trust and says, what am I supposed to do? How am I supposed to evaluate trust distribution requests? They're going to say that the settlor's intent was that principal is not invaded unless it's necessary and prudent, and only for essential things. And so there is a much stronger argument that a successor trustee could come in and be very frugal, you could say, with the principal distributions, even if Mrs. Mcrae has a need for her health maintenance and support, not only because of that may language, but also because there's the admonishment in the sentence that follows that says, restrict principal distributions. So yes, it is possible that a successor trustee could be adverse and could decide to limit principal distributions even more than Mrs. Mcrae has already experienced in the 3 years since her husband has passed.
Now, you're saying there was a 6-year statute.
6 months.
6-month statute. And your client had to make the decision within that period of time before the values were known?
So, yes, Your Honor, she needed to make that call whether she was going to file the elective share claim within 6 months after the appointment of the executor. And you know, the elective share proceeding is stayed right now, pending the outcome of this lawsuit. There will be valuation disputes. We'll have competing experts, appraisals, that kind of thing. But this really is the heart of the dispute, because how this trust is valued makes a difference as to whether she receives an elective share, or whether she receives nothing at all.
Let me ask you this. Is it possible through a trust that you could have limitations where a surviving spouse would receive less than their elective share, 50%, and still be valid?
Yes, and let me tell you how that would work. If the settlor of a trust met the 4 requirements of the statute, for it to be fully countable, in that circumstance, the trustees they would be required to make distributions for the surviving spouse's health, maintenance, and support, but it's conceivable, very conceivable, that those payments would be less than what 50% would have been if you had calculated it at the outset. That is a possibility.
You agree that it's valued on date of death?
I agree that the elective, yes, date of death values are what's pertinent to the elective share calculation.
And we don't know what that is 6 months after the date of death generally, do we?
You don't, not with a complex estate like this, but Yeah, you don't. Not with a complex estate like this. But the universe is essentially closed, and it's a matter of investigating those circumstances.
But if you're going to assert the claim, you still have to assert the claim within the 6 months, not knowing if what you're getting would be equivalent to an elective share.
You have to do it in 6 months, and that's why the terms of the trust are what our legislature has said that you look at when making that determination. One clarification I want to make that the court...
You're not arguing that she's entitled to more than 50%.
Nope, not a dime more. Mrs. McRae, you're entitled in North Carolina to a 50% elective share if you've been married 15 years. Certainly, at 51 years of marriage, Mrs. McRae believes she is entitled to that 50% share of the estate and not a dime more.
And that's true regardless of number of children?
Yes, Your Honor, 50%, I believe.
15
is
years,
close.
50%, you have 10 children, the wife gets half.
I am almost positive that is correct, Your Honor. And that
The old rule was 1/3 more than two.
there was an old rule. It was revised maybe 2011, about a decade ago. And at that point, I believe it went from 1/3 to 50%. And so, again, Mrs. McRae seeks 50%, not a dime more. And an important point to note there is no circumstance here where Mrs. McRae is going to receive the entire amount in that marital trust. Regardless of whether we win or regardless of whether we lose, she is never going to receive everything in that trust. And that's not what we're arguing about. We're just arguing whether this trust is valued in accordance with the default rule for trust valuation under the elective share statute, or whether it fits within this narrow exception.
If she left a will that would bequeath her half to someone other than the children, or just to one child, the trustee would not, that money would never pass through the trust to her estate. Is that your argument?
That's correct, Your Honor. The trust, Mrs. McRae's death, whatever remains in that trust, rolls over to the 4 children. And that's what's, frankly, perplexing about the other side's argument, because Mr. McRae, if you wanted the 4 children treated equally, that's what this document does on its face. And we don't know what Mrs. McRae will do upon her death with her estate planning. And so this entire argument that this estate plan...
With the alignment of the parties kind of dictates that, though, doesn't it?
You would think that it might, but you would be surprised. You know, people leave things to charity all of the time. There are assumptions that are being made here that are required to reach that conclusion that this trust on its face does not benefit the 4 children equally. And putting aside that point, Mrs. McRae is a spouse of 51 years, has a marital interest in 50% of her husband's estate. In order for this trust to be fully countable and to deplete the elective share, which it would in full, it needs to meet the 4 requirements, and there are 2 primary reasons that it doesn't do that. The first, the trust is silent as to the non-adverse trustee requirement, and second, the trust does not provide...
We could rule as a matter of law that any successor trustee under the statute would have to be non-adverse, correct? That would be within this court's discretion to impose that requirement?
You mean if
To
you were
interpret
not-
the statute to say that?
The statute says that in order to be fully countable, the trust by its terms must ensure that there will be a non-adverse trustee for the surviving spouse's
And
lifetime.
you're not, are you arguing that either one of the 2 current trustees are adverse?
No, Your Honor.
Okay. So we could interpret the statute that require any successor trustees to also be non-adverse, correct?
That is correct.
So does that cure that issue?
It doesn't, because that means that it doesn't change the terms of this trust. And so in order for the terms of this trust to ensure, well, in order for Mrs. McRae to know that she will have a non-adverse trustee for her lifetime, language has to be added to this trust instrument. Because compliance...
Or we could construe the statute to require it.
Well, so I agree that the statute requires it, but I don't agree that...
And we could also construe it to require it of any successor trustees, could we not?
I agree that that's what the statute requires. I don't agree that this trust provides that. This trust is silent on that point. So the court would need to write in a requirement that there always be a non-adverse trustee for Mrs. McRae's lifetime into the trust.
Well, if we rule as a matter of law, the statute would require any successor trustee to also be non-adverse. That would cure that problem, would it not?
No, Your Honor. So let me say this differently. So the trust on its face doesn't impose any requirements for successor trustees, completely silent. So the current trustees can appoint whoever they want. And so what the statute requires is that you look at the instrument within those first 6 months and decide if it meets those 4 requirements. Will there always be a non-adverse trustee for Mrs. McRae's lifetime? That's what the statute requires, and you're right. Successor trustees are encompassed within that. This trust doesn't do that. I agree with you. The statute requires that this trustee and successor trustees must be non-adverse, but this trust doesn't do that. Completely silent.
Okay, what is the other defect?
The
Let's
other-
say we can cure that one.
Okay.
For the sake of argument.
All right, for the sake of argument, the second reason that this trust does not meet the statutory requirements is because the terms of the trust do not provide for mandatory principal distributions for Mrs. McRae's health, maintenance, and support. And that is the third requirement of the statute, 33-3.3 AE1C. And the statute requires that principal distributions, it says the trustee shall distribute to or for the benefit of the surviving spouse out of the principal of the trust such amounts and at such times as the trustee in its discretion determines necessary for the health, maintenance, and support of the surviving spouse. Okay? So the statute says that the trustees must make the distributions when the trustees decide that Mrs. McRae needs the money. Okay?
Let me ask you this. Let's presume for the sake of argument that it doesn't, and the demand was made. Let's say you had a trust that clearly required it, but the trustee just refused to do it. You bring him into court and you say, you know, I have needs, I'm entitled to it, you're not doing it. What's the difference?
So the difference is that there are 2 decision points versus 1 decision point. Under the statute, there is 1 decision point for the trustee. The trustee decides, does Mrs. McRae need the money for her health, maintenance, and support? If the answer is yes, they must make the distribution under the statute.
Okay.
Under this trust, there are 2 decision points. First, the trustee says, does Mrs. McRae need the money? Yes, she does. Okay. Second decision point, must I distribute it? No, says I may. And so that's a big difference, especially when you consider the admonishment language that follows.
And that's fatal in and of itself.
That's fatal in and of itself. That is fatal in and of itself. And the rationale actually makes a lot of sense. Because if you only have permissive principal distributions, you could have a circumstance where the trust, if it's fully accountable, fully depletes the elective share, yet the surviving spouse would never receive a dime of the principal because the trustees could decide that she didn't need it. And under appellant's view of the statute, if shall plus in its discretion creates a permissive power, well, the same thing applies to income distributions. So, under appellant's view of this statute, you could have a fully accountable trust and the surviving spouse would never potentially receive any principal or any interest, not a dime. That is a conceivable outcome from the argument that appellants have presented to the court.
Was that the same argument you made before Judge Gorham?
I did present that argument before Judge Gorham. That was one of the arguments that was presented before Judge Gorham. Your Honor.
What about the reformation provision, that there is a provision in the statute to reform the trust to actually accomplish what you're saying is deficient?
So, and keeping in mind, the statutory modification provisions are to reform the trust instrument, not the statute. And so there are 2 of them that they're looking at. There's 412 for unanticipated circumstances and 415 for mistake of fact of law. On the mistake of fact or law, on 412 for unanticipated circumstances, appellants have argued that it is an unanticipated circumstance when one's attorney fails to give effect, quote, to a client's directions and testamentary intent. It kind of sounds like malpractice. Nonetheless, appellant's testimony has been that there was no malpractice here and that the drafting attorney did not err. So the record evidence itself does not support that argument. Furthermore, as we heard today from appellant's counsel, Mr. Mcrae knew exactly what he was doing here. He and his attorney looked at the elective share valuation requirements, they exchanged it in emails, they discussed it. He even anticipated that Mrs. Mcrae would challenge his estate plan if there was any basis to do so. There's nothing unanticipated about any of that. I would also direct the court to the Philip Morris USA case, and that North Carolina Supreme Court case, Justice Newby addressed what is an unanticipated circumstance under North Carolina's trust modification statutes. And in that case, Justice Newby wrote that even a new law is not an unanticipated circumstance. And so the court held that the plaintiffs knew of the risk and that they simply failed to account for it. And the same principle applies here. Because Mr. McRae knew about the statute, his attorney knew about the statute, and for whatever reason, they just elected not to follow the 4 requirements of the statute to fit within that very narrow exception for fully countable trusts.
And
And
what
again,
about the Reformation statute,
what's that?
the last one,
And
about
then-
the ability to reform?
As to 415, for mistakes of factor law, I would also note for the court, this statute was revised in effective January 1, 2018. Prior to that time, trusts could be modified for mistake of factor law, even if they were unambiguous. From January 2018 onward, trust terms must be ambiguous at this point in order to be modified. So our legislature has recognized an additional restriction on courts' ability to modify trust. And here,
Which statute applies to our situation here, the earlier one or the current one?
neither. We do not.
Given the timing of the death,
Oh.
which, if there is, which statute would apply? The current version or the earlier version?
The new version. The new version, the parties agree on that. It applies to all the actions filed after January 1, 2018. So the new statute applies to this. Here, there is nothing ambiguous because the parties agree. The trust instrument is silent as to any requirement on successor trustees. It does not ensure a non-adverse trustee for Mrs. McRae's lifetime.
Counsel, on the issue of, say for argument's sake, reformation is out there. How do you balance the time that it would take to make the allegation for reformation balanced against the statutory requirement of the surviving spouse to make the 6-month election? How do you balance those two with the time that it would take to make the allegation of reformation being needed and the short turnaround time for the election?
And that's a challenge. Surviving spouses have that end bar of 6 months. I'm not aware of any provision that tolls it if a later modification action is filed. And so the modification limitation is not 6 months. So you have 6 months for the surviving spouse, and then the trustees presumably could file a modification action, for many, many years to go. If you have changed circumstances, for example, if there's an old trust that says all the assets should be in Enron, well, now would be a time when then that would be granted, when that would be appropriate. So they are not the same. They are not one and the same.
So you're saying that remedy is not available here?
So trust modification is not available here. Both statutes have specific criteria that must be met. Neither of the criteria are met in this circumstance. And notably on the 415, the appellant...
Let me ask you this. You don't consider the absence of directions on successor trustee, if we did not interpret the statute to require there to be non-adverse, that's not enough to reform it to add that requirement?
So the interesting thing about trust modification is you have to fit within one of the pertinent statutes. And here, none of those statutes apply. 415, for example, you need a mistake of factor law and an ambiguity. Here, there's nothing ambiguous about the fact that that's completely silent. The only mistake of factor law that they have pointed to, for example, is a Scrivener's error. Scrivener's error is like mistaking a date or a name or an address, but what they're asking the court to do here...
Rewrite it,
to change may to shall, to strike the admonishment language on the principal distributions, to write in a new requirement about health maintenance and support, and to add a provision that all successor trustees must be non-averse for Mrs. McRae's lifetime. So not a Scrivener's error. And the parties don't dispute, as I said earlier, that the principal distribution permissions here are permissive. So there's no ambiguity in the trust terms. They just want to say that this fits within the statute, and we don't believe that it does on its face of the document.
how much should the court try to honor the trustor's intent, testator's intent? How important is that?
So, Your Honor, the appellants filed, and this is in the record at page 150 and 151, one of the trustees and the confidant of 60 years filed an affidavit. And in that affidavit, it says, this trust instrument reflects Mr. McRae's testamentary intent. That was in the affidavit of Robert Warwick. So they want to modify it, or at least they're asking for modification, yet their own testimony is that this instrument reflects his intent. They have tried to qualify that in their brief by saying what they meant is that Mrs. McRae allegedly asked her husband to leave her more, and he elected not to do so. That only
Leave her
underscores...
more than what was set in the marital trust.
Yes, and that only underscores the fact that this trust instrument is what Mr. McRae intended, consistent with what Mr. Warwick testified in his affidavit. I would note for the court that if modification is granted in this circumstance, it would create the roadmap for how to disinherit a surviving spouse in North Carolina. It would create the roadmap for it and a no-lose opportunity in order to do so, because here's what would happen. The spouse with the control of the assets could put the money in a trust with permissive principal distributions, like we have here, or permissive distribution provisions, like we have here. And then upon that person's death, the surviving spouse has 6 months to file the claim. If the claim is filed within that 6 months, just modify the trust. Fix the problem, okay? Make the trust comply for fully accountable trusts.
Yeah, but you're not alleging, I don't think you're alleging that your client's entitled to any more than the elective share.
Correct. We are only seeking the 50% of the elective share, and the premise of our argument is that this trust should not be counted at the full value of the $8 million in it, because it wipes out her elective share and she may never see a future dime of the money in there, because the trustees have discretion whether or not to make distributions.
Do you agree that the actuarial, the lifespan of your client is relevant in determining?
It's relevant to the clerk of court, absolutely. And so once this case is resolved, it goes back to the clerk to do that math. It will still be, I think it was like $2.5 million. It was several million will still be the value of this trust to Mrs. McRae. And additionally, there's a relief valve, I suppose you could call it, in the statute. If appellants want to argue that she has received more than that, they can then argue before the clerk a valuation that's even different than that, if they feel she's received more and that 2.5 or whatever the actuarial is too low. But there is no circumstance where she will receive the entire amount of this trust outright. All she is looking for is her 50% share of her husband's estate after the 51 years of marriage that she had, and that is it.
I'll give you a moment to sum up, and I want to ask if either of the other judges have questions. You have any questions? You have any questions? Not yet? Okay.
I can always talk longer.
If you take a moment then to sum up, you've got a few minutes to
All
do
right.
that.
Well, and I see I've got 33 seconds here, but just to
We'll be
summarize-
generous.
Well, thank you. Just to recap, Your Honor, there are 4 requirements in the statute to be fully counted. This trust does not meet 2 of them. And with respect to the modification statutes 412 and 415, the requirements of those statutes is not met. The record evidence does not support it. We ask that the court look at the statute and the 4 corners of this document and the unambiguous language in this document, and that the court affirm the trial court's order. And if there are any questions, I'm happy to answer them. Otherwise, thank you for your time and the opportunity to appear before the court.
You okay? Thank you. Thank you very much. Ms. Aries, did I pronounce that right?
You did.
Okay.
Ms. Ayers,
And you'll reset that to 5, is that correct? Okay.
Ms. Ayers, can I start with a question, please?
I'm sorry?
Up here.
Oh, yes, okay.
Thank you. You believe that the trustor's language complied with the statute, the exception?
Yes, Your Honor, and if it didn't, we should be able to admit evidence.
Okay. And the trustor used the word may,
Correct.
okay? And in addition to using the word may, he actually gave an admonishment to his trustees that only for the necessary expenses, not for unusual or unnecessary. Is that correct?
That is correct.
And did he define the words unusual or unnecessary?
No, but we have the evidence as to what both the drafting attorney and the trustees think it means.
What they think it means. But a trustee down the road could think it means something totally different.
That is correct, Your Honor.
Okay. But the statute says shall. Is that correct?
It says shall in its discretion.
But when it says discretion, it says for health, maintenance, and support.
That is correct.
Okay, so let's take an example. Let's say that this couple, every year, they went on a nice vacation. And they did this every year. That was what their standard of living was. And now the widow wants to do that same vacation next year. Under the way this is drawn, the trustee could read that that's an unusual or unnecessary expense, could he not?
Potentially.
Okay, and so he could limit it to only health reasons and not necessarily maintenance and support. Is that correct?
Correct.
Okay. Now let's take another provision, because what really interests me in this is that the appellant has taken the position that the attorney who drafted this trust didn't commit any errors, no malpractice, anything like that. So what I'm wondering is the use of the word may instead of shall. Is that intentional for any reason? So I apologize for taking so much of your time, but I do have a question. So it appears to me, let's say that the widow was to need extraordinary medical care, okay? And in this state, if you can't afford that type of care, you often end up on Medicaid, and the state pays for that. And you have to spend down your assets. And so if the trust had the word shall, I think it's no question that Medicaid could reach into this marital trust and make them pay for that medical care and spend that trust money down until it was expended. But the fact that they use the word may makes me wonder if the trustees could refuse. And so I think what I want you to address is why are you so sure that the words may and shall in this instance are really the same and that the statute is complied with?
Your Honor, it's because the courts in North Carolina have held that. If you take a look at the Edens case, which is cited in our brief, this is the 1982 First National Bank versus Edens, the court was asked to construe the following language. The trustees, quote, shall have the power and authority in their sole discretion to use any part or all of the income for the support, maintenance, and comfort of the beneficiary. The court said that was permissive. That question has been answered in North Carolina, that shall in its discretion is permissive. May is permissive. How can you look at the two things and say without a doubt there's no compliance, that is clearly, crystal clear, unambiguous?
Well, isn't it fair to say that the language in their sole discretion in and of itself qualified the shall?
As it does in the statute. It's the same language in its discretion. So what the Supreme Court of...
Even said sole discretion.
What the Supreme Court of North Carolina has said, and this is the Woodard v. Mordecai case also cited, is that a power is discretionary when the trustee may either exercise it or refrain from exercising it, or when the time or manner or extent of its exercise is left to his discretion. So you could exercise discretion and say the amount that should be distributed is zero. And let me explain to you why that matters. Opposing counsel, there's two problems with their argument. One is they come at this from the perspective, it's almost as if this were a community property state and the spouse is entitled to half. That's not true. The public policy behind the elective share statute is to make sure a spouse is not left destitute. If a surviving spouse independently has $100 million of assets, a trustee may never give them a penny out of the marital trust. And that is the public policy that this General Assembly said applies, that this trust is there to make sure the spouse is not destitute. In this case, we have a surviving spouse with considerable other assets. The question is not whether or not all of the assets are ever going to be distributed to her. It's whether or not this trust complies with what the statute says is required to be sure she is cared for. And the second problem with the appellee's argument is they want to read the statute to say that the trust must contain the following language. The statute does not say that the trust must contain language saying that there be a non-adverse trustee. The clerk of court could certainly require that as part of the condition of counting this at 100%, because the statute does not require magic language. There's no go-by, there's no form. So, Judge Jackson, to answer your question, you posited me some hypotheticals about could they give her nothing. You're absolutely right, they could. But they could also interpret that same language to allow it. Let me give you some examples of what would be unambiguous. No principal distributions are allowed. Principal distributions are allowed, but not more than $50,000 a year. Principal distributions are only allowed for medical, nothing else. Those are all clearly contrary to the statute. But what's essential could be interpreted to include the things you said. What is necessary and prudent could be interpreted to mean the things you said. So why shouldn't we be allowed to introduce evidence as to what in this case was meant by those words?
Counsel, on that issue, how do you balance the quickness in which a surviving spouse has to make the election in light of the length of time it would take to try to reform if there was an ambiguity? With her having to make this within the short turnaround time, and the strong unlikelihood of it being resolved because of it, how does that reconcile?
Your Honor, I think that there's, at least I don't find an issue with it. I think she has every right to file the elective share claim and preserve that right. And then we learned quickly there was a dispute over what we thought was clearly a trust that complied. So we then filed the declaratory judgment. They wanted the elective share action to continue. We filed a motion to stay. The clerk looked at it and said, I can't tell on this language if it meets it or doesn't meet it. It's not clearly unambiguous. And so here we are. And so our request would be either allow the evidence to construe those words to mean what our evidence shows they were intended to mean, or conclude it's just not clear. Let us modify the trust. If magic language does need to be there, if this court wants to construe this statute and be the first court to do it and say, yes, you have to have the following language in your trust, fine. Let us modify it to have that language. Then it'll be even clearer for subsequent drafting attorneys, drafting trusts to know, okay, I do need to put exactly the following language verbatim in my trust. But here, all the drafting attorney has is the Eden's case, which says shall in its discretion means may, and no other guidance. There's nothing that says include certain language. And he thought he met the spirit and intent of the statute, which was non-adverse trustees. He gave her all the income, and he allowed just for May for discretionary distributions of principal.
I had one final question. If you have a widow that's worth $100 million independently or other assets, under the elective share statute, she would still be entitled to get half the estate regardless of what she had otherwise.
That is absolutely correct.
You do agree with that?
That's absolutely correct.
Okay. You want to take a moment to sum up?
Yes, Your Honor. We, again, just for the reasons I've stated, we do not think this trust is clearly out of compliance with the statute. Therefore, we believe that no one here seems to be able to agree. Therefore, we allege that there's an ambiguity in looking at the trust side by side with the statute, and we ought to be able either to allow extrinsic evidence to interpret it, or, because there's an ambiguity, modify it under Section 415, or because of the links the settlor went to make his trust compliant, determine there's an unanticipated circumstance and modify it. Thank you.
Thank you. All right. Thank you for arguments. We appreciate it. Good arguments and good briefs. Mr. Clerk, will you adjourn court?
All rise. This session of the North Carolina Court of Appeals is adjourned.